I've had a lot of disagreements with Mr. Hooge, but never in terms of his integrity and the way the bar is running.
If you have the intent not only to break the rule but also benefit yourself, then it's disbarment.
And I laid out 60 different misrepresentations by the government lawyer, and yet I'm the one who's being targeted for discipline. And
I was only held in contempt once. I was a young lawyer, I was still in Chicago, and a judge denied a motion to suppress. And he denied the motion to suppress because he was a judge in Chicago, and they expected to get paid to grant them.
Hi, everyone. My name is Maria Gall. I am a district court judge on the 8th Judicial District Court, and today I am hosting the panel on attorney discipline. So I'll let all the panelists who are here to my right introduce themselves.
I'm Daniel Hooge. I'm grateful to be here. I'm Chief Bar Counsel for the State Bar of Nevada.
My name is Dominic Gentile. I am an attorney in Las Vegas, Nevada, member of the Clark Hill Law Firm.
I am Joseph Maridon, and I am also an attorney here in Clark County.
Great. I think we have a panel today that sparks a lot of interest from the general public, but also from other bar members as well. And so just to get the process started, I'll ask Mr. Hooge, could you talk a little bit about the attorney discipline process, the panel, how panelists are chosen?
Yeah, absolutely. So we receive we're on track for about 1,500 grievances this year. That's pretty average, anywhere from 1,200 to about 2,000 grievances a year, just under 200 a month. And what we do is we'll receive those generally online. They'll fill out a form where they'll list the attorney's name, information about the case, what happened, and what they're complaining about. They'll usually attach any type of pleadings or whatever else they have. From there, we have an intake attorney, or an attorney and a paralegal, and they'll review each one of those 2,000 grievances, and they'll just look at it facially and determine whether or not it even implicates any rules, whether or not it involves an attorney that's actually licensed in Nevada, and whether or not it'll go forward into investigation. We typically will dismiss about 60% just at the intake phase because it's just not facially valid. Either they're complaining about someone who's not an attorney, they're complaining about my attorney was a jerk or something like that. It doesn't really implicate the rules of professional conduct. From there, when it's sent to investigation, we have a team of investigator paralegals who will investigate the matter. Typically, that just means that they'll send the grievance to the attorney, ask for a response. They'll pull up any court records or talk to witnesses that may be involved, third-party witnesses or anything, and put together a case and prepare a case report for my review. I'll review the case reports and then I'll assign an attorney to prosecute it. And from there we have what's called a screening panel. It's a lot like a grand jury. It's just ex parte. It's just us presenting it to the screening panel. And that screening panel all panels are 3 members. There's always 2 lawyer members and 1 lay member. And so the screening panel will review all the cases that we have on for that month. Usually there's a handful, maybe 12 to 30 cases. And they'll review each one and determine whether or not it should be dismissed or whether or not it should go on to formal hearing. Sometimes we also have diversions where they can send it off for like a substance abuse diversion or mental health diversion or different diversions. And that can happen at the panel level, the screening panel level as well. Also at the screening panel, they can issue admonitions, which is relatively new. We just included those in 2023. And if they issue an admonition, then it's private discipline and the attorney's name is not listed when it reaches the bar magazine. So that's been actually favorable, I think, in general for the bar. I think the membership appreciates the admonition. We didn't really have that before 2023. And so you asked about the panels. The panels are volunteers, so typically we'll just accept applications. If anyone's interested, they can apply. We try to recruit when the numbers get low, but we try to get around 57 members for both the North and the South. So the state is kind of divided in half. A lot of you've got like Washoe County and Carson City and all the rural counties up in the north are one disciplinary board, and then Clark County and some of the southern rural counties are in the south. And so what we'll do is we have 57 members on each disciplinary board, and they'll just randomly pick panel members for those panels. So like I said, it'll always be 2 attorney members and 1 lay member on each panel. And that's the screening panel and a hearing panel. So if it's screened and the screening panel says we recommend this for formal hearing, then we'll file a complaint, and the respondent attorney will file an answer, and then it will set it before a formal hearing panel. And it's the same composition. You've got 2 attorneys and 1 lay member, and they'll hear it just like a trial. Obviously, there's no jury. They're kind of judge and jury. There's usually a panel chair. One of the attorneys will act as the panel chair and make the legal rulings. If the panel decides on either a suspension or disbarment, it automatically goes up to the Supreme Court. If it's contested and it's a reprimand, it also goes up to the Supreme Court. But if it's a conditional admission agreement for a reprimand or an admonition or anything lesser than that, like a diversion agreement, then it doesn't go up to the Supreme Court. It's just done at the panel level.
Let's unpack that a little bit. So one of the things you mentioned at the get-go is that at least this year you're on track for 1,400 to 1,500 grievances being filed. And as you were explaining that process, it sounded like to me that you were talking about grievances perhaps filed by the public or filed by clients through the bar website. Is there any other way that grievances come to your office?
Yeah, roughly about 50% are clients. Again, these are rough estimates, but 30% are opposing counsel or opposing parties. Then you have judges will give us referrals. You've got just news articles. Sometimes the state bar will open grievances ourselves if we see something in the news, and other various sources.
Okay. And then one of the things you mentioned is that at least about 60% of the cases get dismissed from the get-go. They're facially, there's no facial violation of any ethical rule. Did I hear that correctly?
Correct.
Okay. When something gets dismissed at that stage, do you inform the party who made the grievance?
Yes,
Okay.
yeah, we do.
And then does that party have any sort of, I'll just call it an appeal right or a request that you look at the issue again, or is the door pretty much shut at that point?
Well, yes and no. It's a lot like the DA's office, for example. If a party reports a crime, they don't have any personal interest in the case. They can't direct the district attorney on how to prosecute the case. And that's the same with us. However, we do have a process if a reporting party is unhappy with the dismissal, they can ask for what we call a reconsideration. And I'll take it away from the intake attorney and I'll assign it to one of my other attorneys and have them give a second look at it. And so if anyone that reported some type of misconduct is unhappy with that, then we will give them a reconsideration and assign it to a different attorney.
Okay. Now, if a grievance doesn't make it beyond the screening panel stage, does the lawyer even know that a grievance has been filed?
So if it goes to screening, yes, we will always notify the attorney of a screening. Typically, that's because if it goes to investigation, then the first thing we do is we send the grievance to the attorney and ask for a response. So they'll know that the process has started. And then once we screen it, we'll also tell them, hey, it was screened and this is the result of the screening. So if it was dismissed, they'll know, or if it's going to formal hearing, then they'll also receive a complaint at the same time and know that it's going forward. Mm-hmm. But if it's dismissed at intake, then no, they won't know. So there's a lot of times where we'll receive grievances against an attorney, but it's just not facially valid. and we don't inform the attorneys that time just because there's so many.
Now, you mentioned admonitions, and that admonitions at least at the screening level are relatively new. Can you talk a little bit about how the admonition sanction came about?
Yeah. In 2023, we're looking at just some updates and changes to the disciplinary rules. That's Supreme Court Rules 99 through 121. And as we were looking into it, one problem that we had in the past was that there were what was called a letter of reprimand, and then there was a public reprimand. And for all intents and purposes, they were identical. There was really no difference. So if you received a letter of reprimand, it would be published in the State Bar Magazine. If you received a reprimand, it would also be published in State Bar Magazine. In fact, the costs were the exact same for both a letter of reprimand and a public reprimand. And so it was really confusing. We really try to emphasize progressive discipline. So if you receive like a letter of reprimand, then you shouldn't receive another one for the next offense. It should be a public reprimand and then a suspension and then disbarment and so on. And so it was really difficult to get through that progression because the panels couldn't really distinguish between a letter of reprimand and a public reprimand because for all intents and purposes, they're the same thing. And so we looked at the ABA guidelines, and the ABA is really a standard throughout the United States. Most states follow the ABA. And the ABA recommends a private level, and we didn't have that. I think we did prior to 2007, but in 2007 they took that away. And so it wasn't until 2023 that we brought it back. And that's where the admonition came in, and it replaced the letter of reprimand. And so the penalty is less, it's $750, whereas a reprimand is $1,500, and the letter of reprimand was $1,500. So now it's less, and it's private. It doesn't go onto your name at least doesn't go into the magazine, although the facts do. You're just anonymous in there.
Out of curiosity, where does the financial penalty go? Does it go to a certain fund?
Yeah, it goes back to the prosecution, so the Office of Bar Counsel's budget. But it's not a lot, I could tell you. Our budget's over $2 million for prosecution, and we get about $200,000 a year in fees and costs.
You touched on sanctions a little bit and this concept of escalating sanctions, but I think we've all probably seen sometime the sanction immediately jumps to suspension or disbarment even. How do panels determine the baseline sanction that they're going to impose?
So ideally, you look at, first of all, was there a rule violation? And so that's pretty simple, that's like criminal. Did they break the law? Did they break the rule? And once you find a rule violation, then you ask yourself, what was the mental state? Did the attorney do that negligently, meaning they weren't aware of their conduct? I think the best example is, like if you grab the wrong checkbook, you think you're grabbing your operating checkbook, but you accidentally grab the IOLTA account checkbook, and you write a check to pay your rent from your IOLTA account. You believed that you were grabbing the operating checkbook. You were not aware that you were grabbing the IOLTA checkbook. If it's negligent, then it's generally, if it's a one-off negligence, then it's going to be admonition, meaning one-off, meaning it's not likely to happen again. No one was harmed. You're not likely to repeat it. Or if it's a negligence where someone was injured and it's something that could happen in the future, then you're going to get to the reprimand level. Suspension level usually happens when the mental state is knowing. You know that the rule says you should do something or you shouldn't do something, and you do it anyway. If it's knowing, then it's typically a suspension level, and it can be anywhere from 6 months to 3 years for suspension are the general guidelines. And then there's intentional. The difference between intentional and knowing is intentional, you know that it's against the rules, but also you intend to personally benefit from it. And so that's typically your misappropriation case where you're taking from clients to pay for operating expenses or pay for a vacation to Tahiti or whatever it is. If you have the intent not only to break the rule but also benefit yourself, then it's disbarment level. And then there's also injury that goes with that. Typically, it's kind of the same 3 prongs. If it's little or no injury, you're at your admonition or reprimand level. If there's injury to the client or to the profession or to the courts, it's going to be suspension level. And if it's serious injury, then it's generally disbarment level.
You mentioned, the different levels of scienter, similar to the criminal law. And you peg that generally to the level of sanction. But do you also, both in prosecuting cases, but also the panel in deciding cases, look at the underlying offense? And are there certain ethical rule violations that, just aren't as bad as other ethical rule violations?
Yeah, I think there are. Unofficially, I think that the ABA doesn't really make this distinction, but unofficially, if you look at, you have different duties. You have a duty to the client, and that's generally pretty cut and dried. You're going to stick to those standards. You also have a duty to the courts, and you have a duty to the public and a duty to the profession. Usually a duty to the profession, you get downgraded a little bit. And the duty to profession is usually like your advertising rules, your civility rules. Any duty to the profession where it's like, you need to, for example, like capping, meaning soliciting someone at the scene of an accident or something. It's something that's not inherently wrong, but the profession doesn't allow it. And those are typically, unofficially, they're generally knocked down a level or 2. And so if there's a lot of professional responsibilities that you have that are just duties to the profession. And if you violate those, typically the panels in the Supreme Court of Nevada will look at it a little less heavy than they will if it's a duty to the client. If you steal from a client, they're gonna stick to that baseline. If it's a duty to the profession, then there's a little more leniency generally.
All right, let's talk about that a little bit. Mr. Gentile, so you've heard Mr. Hooge talk about how, maybe duties to the profession aren't sanctioned as highly as duties to the client. What are your thoughts about that as someone who's in the profession and who has to deal with other counsel and issues perhaps of civility?
Well, I think that the way that it's treated right now is the appropriate way. I think that your primary duty is to your client. And to the extent that you're abandoning that, you're probably also abandoning all of the other 3. If you are loyal to your client, chances are, and giving him zealous advocacy, which is what your obligation is, chances are you're probably not going to be doing anything that would intentionally be detrimental to the profession. So if you have done something that a screening panel thinks was detrimental to the profession so that it has to move forward, I think just from a standpoint of why we have lawyers and why we have a judicial system, and why if it wasn't for our system, there'd be a lot more shootouts at high noon on Main Street. I think that a lawyer's probably deserving, honestly, of more lenient treatment if they did something that maybe they didn't think would be damaging to the profession, but others do. So I have no quarrel with that. I think it's working fine. And we do represent a number of lawyers that are taken to task by the bar. And I can't say that I've had a lot of disagreements with Mr. Hooge, but never in terms of his integrity and the way the bar is running.
Mr. Maridon, do you have any thoughts that you'd like to add?
I've heard a lot of "this is how it should be" sort of statements. I'm not sure if it really works that way in practice. I could lay out 60 separate violations by a particular attorney and say, this is how it harmed my client. this is exactly what happened, and yet, it doesn't get past screening just because it happens to be opposing counsel or it happens to be a government lawyer that I'm complaining about. And when I say that, I look at Bar Counsel's report. 159 complaints were filed against government employees in 2024. Exactly 0 of them went past screening. So I question the integrity of Mr. Hooge because what he's saying just isn't true. Whenever there's 159 complaints and not a single one of them gets past screening, that happened in 2023 as well. This year there's been, I can't remember the number, I think 59 complaints or so. 3 of them have gone past screening now. So there's at least an uptick, but it's 3 out of 59 or whatever, and 3 out of hundreds over the last 3 years that have gone past screening. And I don't know what the numbers are past 2023 because they were reported differently. But my own experience, my own case involved, it was a 40-minute hearing in front of Judge Shoup down in Good Springs over whether the trial would go that day or not. And I laid out 60 different misrepresentations by the government lawyer, and yet I'm the one who's being targeted for discipline. And my complaint is just simply dismissed, just swept under the rug. So I appreciate the effort. I appreciate how it should be. I think that's how it should be. I just don't see that in practice.
I have to tell you, I think a lot, the numbers, I don't think, I'm sure he's accurate. I don't know that, but I believe him, okay? But I think one of the things that you have to look at is of those 159, how many of them were made against prosecutors by somebody who was a criminal defendant in the case. If you distill that down, that 159 down to how many were made by a lawyer who was an adversary
Or a
or a
judge.
judge, I think that's the number that counts. I really do believe that. And my best guess is that a lawyer, and I've been in the criminal justice system 54 years, a lawyer is going to really have to have a gripe if he's going to lodge it against his adversary in a criminal case. And I know I've never done it, and I've had a lot of gripes.
And I do, Ms. Maridon, I want to talk about your case later on, and I want to talk about Mr. Gentile's case later on. But before we get there, I want to talk about the most severe sanction that can be imposed, disbarment. Is disbarment permanent?
Yes, in Nevada it's permanent. Most other states it's not. It's typically the ABA recommends that disbarment allow for readmission after 5 years. But in Nevada we don't have that. If you're disbarred, it's permanent.
I hate to put you on the spot, but I guess we're all on the spot, or at least you three are somewhat on the spot. Can you give, do any cases readily come to mind that you could describe for our audience where there was disbarment and it was upheld by the Supreme Court as an appropriate sanction?
I think recently, for example, we had Doug Crawford, where there was, issues of sexual misconduct with clients, and that one went up to the Supreme Court. It was a little different because he actually consented, honestly, because once it reaches that level, generally they'll just consent to it or they won't show up for the hearing, and then it's like a default. I can't think off the top of my head the last time we had a contested disbarment that went up to the Supreme Court and they affirmed, but it does happen. We typically have a half dozen a year in disbarments.
Okay. And you also mentioned another type of, I don't think we should call it a sanction, but you mentioned diversions. Can you speak a little bit about the diversion program and when it's appropriate for attorneys?
Yeah, absolutely. So diversion is typically for the negligence and below. So anytime, if you grab the wrong checkbook, then we're going to try to help you out and make sure you get into some training, do like some general accounting training. We have a trust account training that you can go through. Or any type of, a lot of times we'll have like substance abuse issues where they're just not showing up for court. They're missing a lot of their hearings. And then the judge will refer them and say, hey, I think this person has an issue. we'll send out a letter of investigation. We'll talk with the attorney and find out they do in fact have a substance abuse issue, or mental health. Mental health is becoming more prevalent. So a lot of times we'll see attorneys that have issues and they're like, I'm just stressed out. I missed this deadline or that deadline. It's because I'm overwhelmed. I'm stressed out. I buried my head in the sand. And so in those cases, what we'll do is we'll take it to the screening and we'll recommend a diversion. We'll set them up with our in-lap program. We have a really good in-lap program. Christine Kuzimka runs that. And we have contracts with very good service providers in mental health counseling, substance abuse counseling. And the state bar will really work with you. In fact, anyone can go for free for 5 visits if they're a member of the state bar, if they have any mental health issues or substance abuse issues. So typically a diversion program will run for about a year, sometimes 2 years if it's really bad. But after about a year and the counseling, it's a lot like drug court, kind of, if you're familiar with drug court. And we'll try to encourage testing, random testing, and one-on-one counseling, and also group sessions as well.
So I know, at least colloquially, that a lot of times the we'll call the substance abuse or mental health issues go hand in hand with some of the more severe violations of duties to clients, such as misappropriation of client funds. If you are faced with a case where an attorney genuinely has a substance abuse or mental health issue, but it is undeniable that they also misappropriated client funds, often to fuel the substance abuse issue, which, by the way, is often how defendants get into the specialty courts like the adult drug court. How do you balance those two challenges?
Generally, we stay away from diversion if it's misappropriation. I mean, if it's intentional misappropriation, and I get that the addiction drives that, but nevertheless, if it's intentional, even if it's driven by the addiction, typically it's got to be you've got to have a lot of good mitigation to get it down underneath to the level of a diversion. I mean, it does happen. I'd say, we probably have 3 or 4 cases every year where it should be a suspension. It goes down to diversion for a really serious substance abuse issue. But the rule of thumb, the general rule of thumb, is that wouldn't qualify for diversion.
Okay. I want to return to an issue we touched upon briefly, and Mr. Gentile, I think you at least touched upon it a little bit, which is the issue of civility. The issue of civility has been a very hot topic in the bar, probably at least for the last 8 to 10 years. And Mr. Gentile, I know you've been in this bar for a long time, and you've probably seen it all, and you've seen the ups and downs of the bar, and you've seen the ups and downs of the court. In your view, when should lack of civility be a proper subject of discipline?
I think the biggest danger with lack of civility, and I think you see it most in family court, to be candid with you, I think the biggest danger is that it impedes what you're there for, which is to resolve a problem that real people who are not lawyers are having. And so when you get to that point where you are not you're not recognizing your adversary as an advocate, but instead you're taking it personal, shall we say? At that point in time, you are impeding justice. You are impeding the resolution of those problems, and there are other people, your clients, that are suffering from that. At that point in time, I think it's intolerable. And at that point in time, I think the bar needs to come down. Not because you're a jerk and you're not treating other people with respect, but because you're a jerk and you're not treating other people with respect, and someone's getting hurt other than yourself. All right? I think that the absence of civility is a sign of extreme self-centered selfishness. And I just don't think there's any real room for it. If you've got a gripe with somebody in particular, step outside, all right, have it out. But to the extent that you're going to behave in a way that slows down or makes less efficient the system that's already overburdened, well then you need to be, somebody has to pull you up and tell you, all right? I really believe that.
So let me ask Mr. Hooge about the somebody. So as a sitting judge, sometimes I unfortunately witness a lack of civility between counsel. There's ad hominem attacks. There is, lack of what I'll call courtesies to one another, oppositions to routine requests such as a request for an extension of time to, let's say, attend a family member funeral, right? When those issues arise, does the bar expect that the presiding judge will handle it? Or does the bar expect that the presiding judge will both handle it and make a referral to the bar? Or does the bar expect that the opposing counsel, who might be the object of the lack of civility, report it to the bar?
Yeah, this is a tough one, and this comes up a lot. And this is part of the reason why, like Mr. Maridon stated, that a lot of the grievances don't make it past intake. And when you have active litigation, the general rule is, if you have active litigation, then we look at three things. One, is it subjective? So if it's subjective, then we want a consensus. Like, has this happened before? Is this something where if we polled the public, 99% of people are going to say, yeah, that's wrong? Or is this something where half are going to say, no, that's okay, and half are going to say, no, that's bad? If there's no consensus, then that's an issue if it's subjective. Also, we're going to look at, has other courts ruled on this same issue? Are there other opinions that have this same issue? And if there's not, that's going to rule against us taking the case. And then the third one is, did the judge in this particular case, when it happened right in front of the judge, did they take any action? And if the answer is, no to all three of those, then it's going to get dismissed at intake. And that happens a lot of times. Mr. Maridon, he filed, multiple, half a dozen grievances against district attorneys, but it's in front of the judge, and the judge didn't act, and there's no, it's subjective, where the district attorney is going to say, hey, I didn't do anything wrong. Mr. Maridon is going to say, no, I believe that what they did was wrong. There's no other case law that has this similar issue, and the judge in that case in particular didn't. So those three things, if you fail on those three prongs, then it's not going to go anywhere. And again, that's only for subjective things like civility. If it's stealing money, then none of that, we throw all that out the window. It doesn't matter if the judge ruled or not. It's hard facts. But anything that's subjective like civility, then those are the three things that we look at.
So if I'm understanding you correctly, I think what I hear you saying is that you don't necessarily expect the judge to entirely handle the matter. However, you're going to look at how the judge handled the matter to see if you should independently move forward on the complaint.
Exactly. Yeah, I'd say for example, if a judge rules on it and the judge sends the referral, we actually fast track that. It skips intake and it goes right into investigation. Anytime we get a judicial referral, it goes straight to investigation. If it's subjective, and so it's like I said, it's kind of 50-50. You ask two people in the community and they're both going to tell you two different things. Then we're going to look at, okay, have other judges ruled? And if the answer is no to that, did this judge rule? And if this judge said, no, I'm not going to refer to the state bar, I'm not going to sanction you, then that's really a killer for us. Because if we take that up to the screening panel, it's going to lose 9 times out of 10.
Mr. Maridon, we touched a little bit, or you talked about, complaints that you've made against district attorneys, and Mr. Gentile focused on sort of civility between members of the bar or opposing counsel. I want to give you an opportunity to talk about your case, which is very interesting because it really concerns civility between counsel and the court. And so, or at least that's one of the focuses of the case. And so we really haven't talked about this, even though civility between counsel and the court is also very important.
Sure. And just to be clear, I don't believe that I was ever uncivil in court during any hearing. And there was two focuses in my case. One was what happened in a particular hearing in one case, and the other happened to do with a telephone call I had with a judicial executive assistant, and I probably said something off color. I know I did, but I hold true to this day that what I said was my opinion, and I believed what I said at the time, and I'm entitled to that, and I haven't changed that opinion, to be honest with you, because I've never spoken to that judge. I've never appeared in front of him. I don't know him. The first time I heard of him was when I got an order from him denying the request that my client had made to disqualify another judge. And I simply called up and I said, hey, first of all, I didn't know that this judge was appointed, because Karen Powell, the court administrator, never bothered to send me the notice, even though that was her job. And then I said, okay, well, you were appointed. How come if I wasn't notified, why didn't you reach out so I could make my argument and present evidence? Because that was one of the things the order said was, well, there was no argument, there was no evidence. And I said, my client, this issue, should be heard. And there was I guess a misunderstanding between a hearing and to be heard. Those are two different things. We're not necessarily entitled to a hearing. I didn't expect one, but I expected an opportunity to at least present arguments, present a brief, to present evidence. And my client was simply denied that. And when I was talking to the JEA, she said, well, my judge knows what he's doing. He's been doing this for 50 years or whatever it was. And all I kept getting was her opinion about her judge, and she made him sound really, really bad. And I expressed that, and so that's what prompted the whole entire thing. He read the transcript from some hearing, and it was his opinion that me expressing some opinions about the judge, and Judge Shoup and I, we go back as far as he's been a judge. I've been in front of him many, many times. I've had many, many different arguments with him. I've complained about him. I've said a lot of things about Judge Shoup because he's not a judge. He's a law enforcement officer. He retired from the California Highway Patrol. He is now a judge. He's not law trained. He has somebody feeding him what he believes is authority. And I've argued different points, and there's no valid legal arguments from a defense attorney with Judge Shoup. He's made that very clear. In fact, I just appealed a case that we lost recently, and I won on the appeal, mainly because I made legal arguments and there was no opposition, and he refused to grant the motion. And I said, Judge, there's no reason why my motion to dismiss should be not granted. But he said, no, I'm not going to grant the motion. And he wouldn't tell us why. He would say, well, I'm not making any findings. I'm just not going to grant it. That's a problem. We don't have a judge who is a judge. We have a law enforcement officer who's sitting there with a robe on.
And will you, just for the audience, because everybody may not understand this, I think we all understand what you're saying and how it comes to be that someone that's not legally trained is sitting as a judge. But for the audience, will you explain that?
So he's a justice of the peace. He sits in Good Springs Township. I don't know what the population of Good Springs is, but I think it's in the hundreds. I'm not really sure. That might be in the thousands, but it's less than 100,000, and under state law, judges in those townships can sit and not be law trained necessarily.
Okay. Whereas, for instance, in the Las Vegas Justice Court, in the Las Vegas Township, there is a requirement that all the justices of the peace be law trained.
Law trained, or lawyers are law trained. That's how I refer to law trained or not law trained. He's not a lawyer. He's not licensed to practice law. Never has been.
All right, very good. And I'm sorry, and I interrupted what you were relaying. Is there anything else you wanted to say about your case?
So I guess I was just sort of getting started and getting up to speed. But In fact, after the opinion came out, somebody came up to me and said, "Oh, you called some judge an idiot in court or something." And I said, "No, that would never happen. You can't do that. That's completely inappropriate. In fact, if I had a conversation with him directly, I probably wouldn't say it to his face, but I didn't have a conversation with him. I had a conversation with his secretary, and she made him sound like an idiot, and that's what I said. I have no filter, I have no tact. It just came out. But in court, I was also accused of some wrongdoing, and when I read the complaint that was filed, I said, I don't understand. One thing was that I said, I'm going to appeal any adverse decision. I'm going to do that. And I expressed that. I told the judge that. And the reason I told him is because we were, after 3 hours of sitting there waiting for the case to be called, he announced we're ready for trial. We're going to have the trial. And then, we have a 40-minute discussion about whether the trial should go forward. I needed him to make a decision. Whether we're going to leave or come back or we're going to have the trial that day. We weren't going to have a trial because the trooper wasn't there. And the prosecuting attorney said, "I'm ready for trial." I said, "Great, let's do the trial." And then we had 40 minutes of discussion. I said, "Judge, please, let's just do whatever you're going to do, and I'll appeal any adverse decision." It's like I wanted him to be rest assured he can't really make a wrong decision. He just needed to make a decision. And that was apparently an issue with the state bar. One of the issues Judge Higgins had was that he thought I was calling his intelligence into question. It wasn't his intelligence, it was his lack of knowledge of the law or his lack of caring of the law. I've always called that into question. I still do, and I will. It's just the reality of it.
Mr. Gentile, on Mr. Maridon's case, one thing I took away from reading the case is part of the case talks about, zealous advocacy, balancing zealous advocacy with your right to, make a record as well. Can you talk about your experience and how you go into court and ensure that you're zealously advocating for the client and making your record without stepping over any, I'll call it, a perceived line of contempt by the court?
I was only held in contempt once. I was a young lawyer, I was still in Chicago, and a judge denied a motion to suppress. And he denied the motion to suppress because he was a judge in Chicago, and they expected to get paid to grant the motion to suppress. This is pre-Greylord days, okay? And so in response to that, because yours truly did not pay him, I gave a gesture that was something like, okay. I was held in contempt. The good news is that I spent about 2 minutes in contempt. He had his bailiff, who was my friend, take me to his chambers, and then come back about 5 minutes later and said, "Get out of here." And I said, "No, I want the judge back here." And he said, "Dominic, get out of here." And so I left. But you can't make up stories like that. But the bottom line to it is, except for that one situation, for which I was extremely glad that he got indicted and convicted later, not for that situation, but for his behavior, I've never been held in contempt. And I guess I'm good at hiding it. I don't know.
Meaning you have contempt, but you're not showing it.
Exactly. Just because you have it doesn't mean you have. It's like a golf club. It doesn't mean you have to use it that round. Okay. But more seriously, what does it gain anybody to demonstrate an absence of respect, not for a court, but for a judge? A judge is a court, and the respect has to be paid to the court and to the whole concept of there being a court system. And so, you know, I teach trial advocacy, and one of the things that young lawyers in particular do, I know I did way more when I was a young lawyer, is you get angry. You get angry at judges' rulings. Okay, well, what's the purpose? What's that going to get you? You know, it's all it's going to do is make you angry and not think as clearly as you should be thinking, because the judge is about to make another ruling. Okay, and maybe she'll get this one right. You know, I think there is a fine line, but I think that we need to do a better job, particularly with our younger lawyers, to make them understand that by biting your tongue, it does not mean that you're obsequious. It does not mean that you're going to let a judge run over you or run over your client. And as you gain more experience, you will learn techniques and methods for seeing to it that your client is zealously represented and a record is made, because it's all about making the record. Mr. Maridon hit it right on the head. It's all about making the record.
Sometimes you have to explain that to the judge, though. Like judge, I understand you've made your ruling, you've made up your mind, but if you would allow me to just make a record. And it's even some, they'll be like, what are you gonna do that for? Judge, I think you made a mistake and I'm gonna probably appeal this. Let me make the record so that way we don't have to come back or we don't have any issues on appeal.
And that's something that needs to be fought for, tooth and nail, the right to make the record. And the judge, I have been in front of judges, I'm sure you have, and you have even when you were a prosecutor. You've been in front of judges where the judge wanted to cut you off because the judge had I don't know why, because, okay? I'd be speculating as to why. But the bottom line to it is that there's a record that needs to be made, and it's a lawyer's first obligation to make that record when you've had a ruling go against you.
Let me ask Bar Counsel, given the decision in Mr. Maridon's case, has that impacted the prosecutions that the disciplinary panel, or rather Bar Counsel, might undertake in similar situations where there's a perceived, I guess, lack of civility or a perceived contempt between counsel and the court?
Yeah, definitely. I think that they really defined it pretty clearly. You have to have some kind of intent to disrupt the proceedings, which is a pretty high standard. We have had cases that we've prosecuted after Mr. Maridon's case that have gone through and were successful, but it's a pretty high standard, and so there's a lot of cases where we'll say now that that's just not. We can't proving intent for anything is very difficult already, but intent to disrupt a tribunal, most attorneys are just angry and they're blowing off steam. They got a ruling against them or whatever, and there's no intent to disrupt the tribunal, and so that standard is very, very high. Although I will say, like I said before, we have tried a couple cases. For example, when an attorney sets a deposition for Christmas Day or something like that, then it's like, that's pretty clear what the intent was, and so it definitely affects us because it weeds out a lot of those lower, lesser cases, but it's good, in my opinion, because now we have a pretty clear standard to look at.
I want to give Mr. Gentile now an opportunity to talk about his case, which is a really seminal case. It was appealed all the way to the U.S. Supreme Court, and Nevada's decision was reversed in Mr. Gentile's favor. And the case is particularly I would say it's particularly interesting because it is about the intersection of your ethical duties, right, including your ethical duties to your client, as well as your First Amendment rights, both as counsel, but also speaking on behalf of your client. Mr. Gentile, please kind of tell me, why don't you just, for our audience who doesn't know, if you could just provide a brief summary of your case and the outcome.
This goes back a long way. This goes back to the 1980s. And there was a case involving, and I think it's still called Western Vault Company. I think it's a different, I know it's a different owner, but I think it's still called Western Vault. And to make a long story short, the Las Vegas Metropolitan Police Department was operating an undercover reverse sting where they were flashing cocaine and unissued American Express traveler's checks, which you can't even buy one these days, but in those days you could. And to make a long story short, this was a 24-hour private vault. You can get access to it any day, any time of the day or night. And there were only 2 detectives that had access to the vault. And they did not tell the vault company that it was a Metro vault or what they were doing. And it was totally anonymous. In other words, if you had a vault box there, you could get in and out. Nobody ever asked your name. And that's just the way it operated. Well, you can appreciate the kind of clients that a place like that might attract. And one day, one of the detectives went to the box, and there was about, I think, my memory is there were 6 kilos of cocaine missing and about $300,000 of unissued American Express traveler's checks. And so that you understand, an unissued American Express traveler's checks is bearer paper. It cannot be reported as stolen because it's never been reported as owned. All right, and so it's never going to show up on a hot sheet. So that detective obviously told the sheriff. The sheriff proceeded to have both of the detectives pass a polygraph that was administered by the Metro in-house polygraph guy, and made a public statement the next day that this stuff was missing and that both of his detectives had passed polygraph tests. From that moment, that was in February of one year, don't ask me which one, and it was February of the following year that the indictment was returned. And for that whole year, almost without a day passing, there'd be something mentioned in something called a newspaper. There used to be newspapers. People used to buy these paper things and read them. Every day in the newspaper, every day on network television, there would be some sort of a story because it had legs. And finally, when the indictment came down, in my mind, it became important to address publicly the situation. We hadn't done it until then. And the reason that it became important wasn't so much that we were going to change the public's opinion, but one of the things that happens when you're representing a criminal defendant who has been who is otherwise a very respectable member of the community, but now has been taking a media pummeling for a year, is that they lose their will to resist. And I knew that we had a case that I could win. I knew that we had a case that was defensible. And the last thing that I wanted to have happen was to have my client lose his will to resist. And so we held a press conference. But I knew, because I had never done one before, in the sense of actually calling a press conference. I've spoken to microphones in my face since I started practicing, but that's not arranged or prearranged. But I knew that there were rules, but I didn't know what they were. And so the night before, Gene Porter, who became a judge, but was my law partner at the time, and Wenley Jensen, who became my wife, but was an employee of mine at the time, we sat in our library and we probably spent the better part of 5 or 6 hours researching this issue, looking for whatever we could find. And we came to conclude that we could make a statement, but it had to stay within certain boundaries. So the next day, we actually held a press conference. It's still the only one I ever had, by the way. Never, and not because of any reason other than I don't need to. You know what I'm saying? The case hasn't called for it. But we held the press conference, and I said what I said. Good news is I wound up with raw footage because it got viewed by a lot of courts after that. It wound up above the fold on the newspaper the next day. And as luck would have it, then Chief Justice Cliff Young was attending a prosecutorial misconduct meeting that was taking place at Rick Wright's office. And there were members from the bar and from the judiciary and from the prosecutors' offices and civil lawyers. And Chief Justice Young walked in there, and I'm told, I wasn't there, walked in there, threw the newspaper on the conference table and said, we're here about prosecutorial misconduct. What about that? So he's the guy that actually started the ball rolling with the complaint against me. He's the man who actually filed it. He never admitted that. 2 weeks before the oral argument before the Nevada Supreme Court, we were waiting for him to recuse himself. He never did. Okay? We had to file a motion, and he never contested the motion. Then he recused himself. But he never did. So we had the argument in the Nevada Supreme Court. I was represented by Neil Gallitz at that point. And the Nevada Supreme Court, in its infinite wisdom, ruled 4-0 against me because Cliff Young didn't sit. And the last sentence of that opinion, because it dealt with the rule, the opinion dealt with the rule. And we, of course, raised something called the First Amendment challenge to it. And the last sentence of that opinion, if you read it, the Nevada Supreme Court, is that we find no merit to any constitutional issue, either under the Nevada Constitution or the federal Constitution. One sentence rejection of the constitutional issue. Obviously, we didn't stop there. And if somebody would have asked me if I thought that the United States Supreme Court would take jurisdiction on that case, I would have laughed at them, because I simply did not. I believed very much in the issue, but I just didn't believe that the court was going to take it. And obviously they did. And it was a splintered opinion, as you see. It was 4 on one side, 4 on the other, and then Justice O'Connor was on both sides. The good news is that one of the sides she was on worked for me. But what probably needs to be said, and Dan will back this up, when that case was decided, the next day, well, he doesn't know this, the next day, it turned out that because of that case, a number of lawyers in Nevada came to me and said, Dominic, run for the Board of Governors. And so I did. And I won. And once a year, the Nevada Supreme Court meets with the Board of Governors. That year, it was the day after the United States Supreme Court ruled my way. Okay? So it was, you have to learn how to be a good winner in life. All right? And it was one of the highlights of my life to walk into that room and shake everybody's hand and have them say to me, more or less, you did it.
Yeah.
And I responded, not at all, other than to say, thank you.
Very gracious.
It was more than gracious, it was prudent. All right, because they're still the Supreme Court, and I'm still just an advocate. But what happened after that, and this is where Dan will back it up. Basically, the Board of Governors said, Stu Bell was the president of the board at the time, chairman of the board. And he said, you broke it, you fix it. And so he said, he basically put together a committee. I happened to be on the Board of Governors at the time. And I was on the committee, and Neil Gallus was on the committee, Franny Forsman was on the committee. I don't remember everybody else that was on the committee. There were quite a few people, civil and criminal, and prosecutors. And that committee wrote what is currently the rule, not just in Nevada, but the ABA then called us and asked us for our work product, and the ABA adopted the Nevada rule. And in essence, what it boils down to, at least the way I read it, counsel, is that you have a right of reply. You know, there's certain things you can't go out there and start the fire, all right? But if the fire is already going, you could use the First Amendment to try to douse the fire. And I think that's pretty much a way of summarizing it that even a lawyer could understand.
Yeah.
This case stands for two propositions. Number one, it was Gentile versus State Bar in Nevada the day that it got decided, and Gentile was the State Bar in Nevada. He was on the Board of Governors, so it was on both sides of the case that day. And the other thing that it stands for is the proposition that I'm easily confused by the English language.
One of the distinctions Justice Kennedy draws in his opinion is the difference between the type of speech you made in that case, which was a criticism of the government, of elected officials, right? Core speech, versus and the First Amendment rights attendant to such speech, as well as when and how those rights can be curtailed, versus other types of First Amendment rights with lawyers, such as lawyer advertising. And I was going to ask Bar Counsel if you could expand upon a little bit how a lawyer's First Amendment rights are implicated by the ethical rules outside of Mr. Gentile's context.
Yeah, when you talk about commercial speech, like advertising, there actually have been some other opinions related to that as well, and they've actually cabined that quite a bit in addition to just your general free speech, like core free speech. And so it really limits what we can prosecute. Typically, we don't prosecute anything unless it's just a blatant, like misleading false statement. There's a lot of advertising rules. I don't know if I should say this, but technically a lot of those advertising rules, if you violate them, we're not going to prosecute them because they're not prosecutable. The only ones that we can really prosecute is if it's false or misleading. If it's false or misleading, then we'll prosecute it. If it's, I guess I can't think of any examples right now, but we'll get a lot of advertising referrals. Hey, this billboard's violates the rules, and typically what we'll do is we'll call up the attorney and say, hey, will you fix it? And they will. 10 times out of 10 they'll fix it, and then we don't have to worry about it. But if they really put their foot down, that we're actually pretty limited on what we can prosecute.
I seem to recall, and I may just be misremembering, I thought in Nevada attorneys had to submit advertisements to the bar for approval and ahead of time. But from what you're saying, it sounds like sometimes they may not do that.
Yes, yeah, they don't. You're right. They do have to submit it to our advertising committee, and yes, they do not always do that. And so a lot of times ads will get out there that violate the rules. And like I said, we'll just give them a call and they'll typically fix it pretty quickly.
Okay. One final topic before we wrap up the panel, because I think it's drawn a lot of interest from the public, is the rule of candor to the tribunal, which I am personally invested in as being at least one of the tribunals. When is that rule violated?
Again, this is one of those rules that's very subjective. If it's an out-and-out lie, like you can prove it's a lie, then sometimes it's objective, and we know it's easy to prosecute. But I'd say most of the time, generally, it's something that's very subjective, and where one party, it's usually opposing party, will say, hey, they lied to the court. And again, we'll take a look at it and we'll say, if we polled the community, is this going to be a consensus issue? Is everyone going to agree that this is a lie? If it's no, that's 50-50. Take for example something that's highly political, like the false electors cases. We got a lot of grievances against them, and the question is, were their complaints frivolous or were they not frivolous? And so that you take a look at that and you say, if we polled the community, is that going to be a straight 99%? Everyone's going to say, yeah, that's frivolous. Let's throw the book at them. Or is that going to be kind of split down the middle along the ideological and political lines? And so we'll look at that. And then again, we'll look at, has this issue come up in other departments? Like maybe not in your department, but have other judges ruled on this similar issue and they found that did lack candor? Then that'll be a strong positive for us. And then finally, did the judge in this case in particular say, yeah, that you were dishonest to me? And that lacked candor, and the judge already either referred them to the state bar or issued their own sanction some way. Sometimes it's just a footnote, but that's good enough for us. But if you look at that, then that's kind of how we weigh it, and it's very difficult to weigh. But that's how we analyze it and determine if it's a very subjective issue.
Mr. Gentile, I saw you shaking your head.
Yeah, I have to tell you, this is violated. This rule is violated with frequency, and mostly in criminal cases, and I'm going to explain why I say that. For whatever reason, any civil litigator knows that if you're going to make a statement of fact in a pleading, maybe not the complaint, I say maybe not, but if you're going to make a statement of fact in a pleading, you not only have to comply with Rule 11 to do your due diligence, but you have to support it usually with something in the nature of an exhibit or an affidavit or a declaration. If you're going to make a statement of fact, you have to have support for the statement of fact.
There is a district court rule on that.
Okay, yes, there's more than just the district court rule. There's a statewide, an 8th judicial district. I have a brief on this, but for whatever reason, I do not know. I don't want to think it's because the district attorney and Metro control so many votes and we have elected judges. But for whatever reason, in a criminal case, that rule requiring factual backup is almost never honored. And what you will see, and probably lawyers ought to call it to your attention more, but they don't, all right? What you will see is you'll see statements of fact in a motion or in a opposition to a motion made by both sides, made by the defense and by the prosecution. Not only is there nothing to back it up, but I will tell you, because I know it to be true, that I have seen statements of fact very recently in pleadings where at the hearing, the statement of fact was totally debunked and belied by the evidence, totally. And it turned out that the person who made that statement of fact in the pleading never interviewed the witness, just made it up out of whole cloth. That is an absence of candor to a court.
How do we fix that?
Snitch.
You mean complaints to Bar Counsel?
Maybe to the judge. Yeah. All right. But what I said, and Judge, please, I want you to understand that this has nothing to do with you as a judge. But it only makes sense that somebody who has to run for office does not want to alienate an organization that controls so many votes because of the number of people that work there and their families and the people that they influence. So if a lawyer is going to make that complaint, they better be able to back it up. But the one thing that we have to do is we have to call that to the court's attention more. It's a place where we're failing.
How would you like the court to respond?
I would like the court to say to everybody, not just civil litigants, but to everybody, you've made a statement of fact in here, and I don't see anything to back it up. What do you got? Rule 11 doesn't apply to criminal procedure, okay? But you still have candor to the court. You still can't make things up. You can argue what a set of facts means, but you can't supply the foundation for the argument with a false fact or a fact that you did nothing to determine. You just think it happened that way. All right? And that's where the problem comes in. And I'd love to hear your thoughts on that.
Yeah, I'd have no qualms about prosecuting that. I think it comes back to what I said earlier, though. It does really, I have a very uphill battle when the judge looks at it and says it's not an issue. If the judge, sweeps it aside and says it's not an issue and there's no other case law on it, then I go before the panel. And I think a lot of people think that, like I'm judge, jury, and executioner, but it's not. I don't have as much power as people think I have. I can bring the cases, but ultimately I've got to convince a panel of your peers who generally favor the other lawyers, and then I got to go up to the Supreme Court. So it's a very uphill battle. If I take that case up to the panel and I say, hey, look, these facts weren't supported at all, I have no qualms about that. I've never shied away from a challenge or a fight, and I would.
I think it needs to be something really significant. I mean, just
yeah.
But if it is significant, if it's something that a case might turn on.
Yeah. What I'm saying is I would love if I got some support from you, where you bring it up to the court and the court says, yeah, I agree, and give me at least like a little footnote or something like, hey, that was a violation, because that would make my life so much easier. Then I could take it up, I can get past the panel, and I can get to the Supreme Court.
Where does, you spoke about these different levels of scienter, right? The negligence, the intent. Right? Negligence, you gave this checkbook example. You meant to grab this checkbook, but you grabbed that checkbook. In Mr. Gentile's example, it might be, I meant to say this, but I accidentally said that, right? What about I think Mr. Gentile suggested this, I can't remember the words he exactly used, where it's not maybe quite intentional, but it's reckless. I think you talked about where they didn't investigate the fact. How does the bar look at, I guess, gross negligence or reckless behavior?
Oh, that's interesting. I actually brought this up to the Supreme Court 2 or 3 times over the last 6 years. Every time they shoot me down, but I've actually argued for like that mid-level where it's, look, this is more than negligent. It's not knowing, but it's definitely more than negligent. And they're just pretty reckless. They're not even trying to interview witnesses. They're not even trying to do their due diligence. They're just drafting the complaint, like out of whole cloth. Like
they're flying by the seat of their pants.
Right. And so I've argued, hey, that's a reckless level. That's closer to suspension, at least like give them a state suspension or something. And the court said, no, we're going to stick to the 3 levels. So typically it ends up being negligent, and they'll get a reprimand or an admonition.
So there's no, at least in Nevada, and I don't know if it's this way in other states, it's just negligence, knowing, or intentional.
Yeah.
That's interesting.
Yeah, there are a couple states that have that mid-level where it's like a reckless, like Florida. I know there are some others, but I tried to get that here, and the court said no.
Mr. Maridon, any thoughts on this topic, candor towards the tribunal?
Well, I don't know. I just find Mr. Hooge's statements a little bit disingenuous. Whenever I'm accused of committing a felony, my client's accused of committing a felony, over whether a trial is going to go or not, and I provide a transcript, and the attorney's, announcing ready for trial when he's clearly not because he doesn't have a witness, and then making all of these false arguments to the court, and the judge is obviously not reprimanding him because he's a law enforcement officer and he's going to take whatever he says as authority. And then he goes to the state bar, and all of these are objectively lies that are being told by the prosecutor, and they just get a free pass. So there really are no standards. There's what the prosecutor can do, and there's what the defense attorney can do, and they're just two different things. Again, judge, jury, executioner, or free pass agent is sitting right here with us, and I just find his statements to be totally disingenuous.
Do you think defense attorneys are held to a higher standard with regard to, I'm talking about criminal defense attorneys, are held to a higher standard with regard to, or a more strict standard with regard to candor towards the tribunal? Because I heard Mr. Gentile saying, Mr. Gentile used an example of prosecutors, but I think I heard Mr. Gentile, you say it should apply equally to both sides. Yeah.
Yes, I think yes, absolutely. I look at cases like what happened with Conrad Hathan. He's kicked off the bench.
I defended the woman he held in contempt.
Yeah, she's being held in contempt, and he's eventually kicked off the bench. I don't know what the prosecutor did in that case. I wasn't there, but he's obviously, he held that standard one way or another. Judge Shoup, he like prosecutors do no wrong in Good Springs, police officers do no wrong in Good Springs, but defense attorneys don't bring anything to the table in Good Springs other than, I don't know how he views me, but I'm a thorn in his side. In fact, I've had other judges call me a thorn in their side or the bane of their existence. It is a double standard in my opinion, and that's my observation from the outside looking in for sure.
Any commentary on what Mr. Maridon is saying?
Not just on his case, but I was present, obviously, for the oral argument in the United States Supreme Court in my case. And a fellow by the name of Robert Klonoff, who teaches over at Lewis and Clark now, argued it for the state bar. John Howe was the bar counsel, but he didn't argue the case. And Robert Klonoff is making the argument that a defense lawyer, I was a defense attorney, and I was making this statement because I wanted to prejudice the potential jury that was going to come later. And Justice Marshall looked at him and he said, "Mr. Klonoff, do you really believe that a criminal defense lawyer saying his client is innocent is going to prejudice anyone?" And that kind of tells you how the defense bar is perceived. All right? Should it be? Well, some defense lawyers should be. Yeah,
Sure.
okay, I'm not going to deny that. It is a different role, I'll give you that. But it's, that doesn't mean that they shouldn't abide by the same rules. And I hear what he's saying, and I believe it's there was a time, that does not apply in all of the rural counties, and Mr. Hooge and I had a case when he was a prosecutor where it was the absolute polar opposite of what Mr. Maridon experienced, because a judge who was faced with a room full of people who were grieving the death and permanent disfigurement of someone, the judge actually ruled against those folks who were from that county because he felt strongly that the right legal decision had to be made the other way. And I'm sure you remember that.
Yeah.
That what he's saying applies to a judge, and maybe it applies to all the judges in Good Springs. Do they have more than one?
No, just
Oh.
Yeah, that's it.
I don't know, but there is merit to what Mr. Maridon is saying.
Mr. Hooge, I want to give you the last word. Any parting comments, as well as can you tell, I think we opened up with the grievance procedure, but if there are people watching that want to file a grievance, can you also direct them to where they need to go?
Yeah. If you go onto the State Bar's website, let's see, nvbar.org, you can go on and it'll say for attorneys or for the public. If you go to for the public, there's a drop-down box, and it will say problems with an attorney, and there's a link for filing a complaint. You can file a complaint on there. We also have fee dispute. If it's more an issue with your fees, you can go on there. Typically, I warn people in this day and age with AI, what we'll see a lot is we'll see someone type in to AI, hey, draft me up a complaint against this attorney because I think this attorney did this, this, and this. And what will happen is AI will generate something that's just conclusory. And it'll say that, the attorney did this, this, and this, but there's no facts involved. And typically those will get dismissed pretty quickly. So if you want your complaint to survive the intake process, then just give us the facts. Don't add any opinions or conclusory statements. Just say, this happened, X, Y, and Z. Let us take a look at it. And then those are more often the ones that are going to get past intake and get onto investigation and prosecution. And so, AI is a great tool sometimes, but in this case, we see it all the time. That's why 60% of our grievances don't make it anywhere, because we'll get this AI recitation that says, the lawyer violated this rule, this rule, this rule, this rule, but there's no facts to back it up. It's just very conclusory. But other than that, our primary goal is to protect the public. And so we want to make the legal system efficient. And so that goes towards the civility. We also want to protect the clients out there. If you hire an attorney, we want to make sure that attorney is both competent and ethical, honest, someone who's going to be diligent on your case and work hard for you. And also, we want to make sure that the reputation of the bar as a whole is a stellar reputation.
All right. Well, thank you. Thank you to each of you for taking your time tonight and speaking on this very important topic.